Bismillahir Rahmanir Rahim. Alhamdulillah wassalatu wassalamu ala Sayyidina Rasulillah wa ala alihi wa sahbihi wa man wala. Welcome back to another discussion of these modern transactions. So today we're going to talk about something that's very important. Maybe we don't think often about it, but it's something that is very important when we talk about modern transactions, which is rights. In the Sharia, we have rights. There are huquq. And some of the rights are established by text of the Sharia. So there's a Quranic verse or a hadith that is therefore and subsequently confirmed through ijma', through consensus, that there's a right. So that's an explicit right. But then there's also implied rights. So for example, the man has an implied right to divorce or to make a divorce pronouncement to his wife. So you can use that as an example that when you get married, it's not something that you're going to necessarily exercise, hopefully not. Hopefully the marriage is successful, but it's an implied right. So we have explicit rights and implied rights. Now, in looking at modern transactions, we're going to abstract, those are examples, but we're going to look at the philosophy behind that, the legal theory behind that, abstract that, and talk about, well, what kind of rights do we have in the modern world as it relates to trade rights? So are there trademark rights, intellectual property, patents, those type of things? And that's what the topic is in this lecture. How does the Sharia look at those rights that are modern? Because these are modern terms, but of course they are very similar to what we have in the Sharia. So we want to look at rights in the Sharia, the first sort of part of the discussion, an elaboration of what I just said in the first minute, and then we want to look at the type of rights that are claimed in the modern world, such as, let's call them trade rights to make them general, and therefore how do we kind of put those two together? Intellectual property, patents, trademarks, branded goods, trade secrets, those type of things. How does the Sharia look at them? So we're going to move a little bit away from the money, which we talked about in the last lecture, and in this lecture we're going to look at the rights, and especially when it comes to intellectual rights, which is the core of so much of international trade and disputes in the modern world. So those are the main topics. We'll begin the discussion in the next clip, inshallah. Okay, so let me just get my notes up here so we're on the same page. So when we talk about rights, as I said in the introductory remarks, we have any legal system is going to have a discussion on rights, whether it's explicit or implied. Of course, in the Sharia, we have rights when certain conditions are met. So there are rights that are established through the text of the Sharia, responsibilities that are established through the text of the Sharia, as I mentioned, and there are many rights that are implied, what we call al-ma'nawiyya. A wali, for example, a guardian has the right to marry his child, has the right to do this for their child, do that for the child. A husband has a right to do this, a wife has a right to do that, so on and so forth. And then, if you think about like inheritance law, when somebody dies, then there is a right that the inheritors have a right to claim that property. Or if somebody is in debt, they have a right to call on that debt. So rights, the huquq, are all throughout Islamic law. It's just that the structure, the way that Islamic law is written, is not written with that leading. The way that Islamic law is written, as you guys can tell hopefully by now, is that it follows the direct discussions found in the hadith literature. So if you look at a book like Al-Bukhari or Muslim or a Tirmidhi, let's look at a Tirmidhi, for example, the Sunan of a Tirmidhi, radiallahu anhu. I mean, that's basically the sections of Islamic law. Those are just the proof texts for those points of Islamic law. Where do we get those chapter headings? And it's from the hadith themselves. So the way that the Islamic law is written, classical, what we call al-fiqh al-mawruth, that which we've inherited, that which we narrate to you with our direct chain of transmission back to Imam Shafi'i radiallahu anhu, or any of the great Imams radiallahu anhum ajma'in, follows that order. That doesn't mean that rights are not there. In the modern legal system, they're focused on rights. And, there's a whole rhyme and reason why that's the case. And perhaps it is the issue of the implied, one can say that the implied understanding is that everyone is in conflict and therefore the law is here to regulate that kind of conflict, so they're going to focus on rights. That doesn't mean that we don't have rights. And that's why this class is important, because all of the fiqh that we've taken, you can't just leave it at that in its classical mode. You have to be able to interpret for the modern world. So anyway, the important points is that we have rights, and the Sharia confirms those type of rights, whether they be explicit rights or whether they be implied rights. If I buy a house, if I buy a car, let's say a car, if I buy a car, then I have the right implied to drive the car wherever I want. No one, I can't buy the car and then somebody limits to me. But if I rent the car, then in the rental agreement, there will be a limits to how many miles or kilometers you can ride. There oftentimes are these clauses about gas. You have to, if you bring it back less than X amount of liters or gallons of gas, you have to pay such and such, so on and so forth. So there are implied restrictions, and that's the right of the owner, because I'm not the owner of the car, I'm just using the car. Well, it's very similar to when we talked about in different types of transactions. If you like rent an animal and then the animal dies, who's responsible? Where is the daman? Well, if you did something that the animal's not supposed to do, or if you, let's say, you put more weight on that the animal can carry because the owner told you, this is an X kind of animal, it can only carry X number of weight, and you overdid that, then you're responsible. But if the animal died, the death of Allah subhanahu wa ta'ala, its time came and Allah ta'ala called it back to Him Jalla wa Ala, then there's no daman, you don't have to cover that liability. Implied in that is rights. Okay, so the important thing is that Islam acknowledges rights. Now, when we talk about the modern stuff, the rights of intellectual property, well, intellectual property right in the modern world is saying, well, I came up with this design. This little remote control, this Sony remote control, I designed it, put the colors on it, the text, the font, its functionality, the circuits on the inside. The real thing about this is what's on its inside and what it can do vis-a-vis the camera that I use to record or the microphone that I use. So somebody designed this, and what we call in the modern world R&D. There was research and development, so they put an upfront cost in developing that, and in that upfront cost came intellectual investment, which is the most important investment, because you can have the same amount of money that Sony has. I mean, it's very unlikely, but you won't be able to come up with the same product or the same idea unless you have the brain power to put that thing together. So the intellectual property, which in our discussion would involve something like I just said, intellectual property, like an invention, as in a patent, or an author that wrote a piece of literature, and therefore exerted a lot of effort to put those words together. A company that has a trademark, like a logo, think of like Coca-Cola or Nike, these famous brands that now it's just like a symbol or a certain way that the brand is written, that becomes a mark. We call that a mark in the modern world. So if I buy a piece of clothing, a piece of fabric, and I put a Nike logo on it, or if I have a drink and I put the Coca-Cola logo on it, I'm obviously taking someone else's intellectual property to be able to sell that. So the reason this becomes important, other than the potential theft of intellectual property, is the money that's involved. Because if I have clothing and I'm putting another, like a Puma brand on it, or Nike, I'm just making these examples up, then therefore I'm basically telling people this is at that standard, and therefore I'm trying to make money. So I'm making money for myself off of someone's intellectual work. So it's a kind of theft. And that's why there's a lot of disputes. Now, trademark law, because I know a little bit about this from my own personal work, it's very dicey because unfortunately, or I don't know, fortunately, I haven't had time to think about it, but there is no unified, universal way of registering. And many of these large brands, actually, they have to go to individual countries and jurisdictions and register their brand, their mark there, which is very, very costly. So if I start something, for example, in Tunisia, and I have a Tunisian brand, that does not necessarily default mean that I can't use that brand in Mauritania. Now, of course, there will be disputes and things like that, but unfortunately it's not that clean. So in this class, in this lecture, I'm not necessarily focusing on that type of manifestation because that's a little bit beyond our purview. That's sort of litigation and things like that. Here we just want to talk about the concept. What does Islamic law say in the modern world? How does Islamic law opine from a fatwa point of view on intellectual property. Clearly, it's problematic because if I take your work, if you wrote a poem and then I take it and I put my name on it and it was an amazing poem and I sold it, people are going to say, oh, Tariq is a poet and he did this and he did that, but I didn't. I just stole your work. So obviously there's a problem in that. So that's something that becomes a huge point of discussion. Now, because Islamic law acknowledges the overt rights that are established through the text of the Sharia, in addition to the implicit rights, there is no obstruction from Islam supporting the concept of intellectual property. So intellectual property is part of Islamic law, obviously. And especially intellectual property, because the ulama in the past, there were these problems where people would steal like different things. Imam Suyuti was complained of stealing different works, and he wrote a work, something al-farqu bayna al-ta'lifi wal-sariq, al-masalik or something. It's like a rhyming title. I can't remember the whole title, but he wrote to defend himself. There's a difference between somebody who writes something and therefore takes what previous people wrote, put it together, and that's my ta'lif, that's my writing, and then a sariq, I just stole someone else's writing. There were ulama where people stole their writings, and lesser wannabe ulama would steal the writings and put their names on it. So this is a huge concept, and I don't know if you remember this, but when we looked at the Baiquniya class, in the hadith nomenclature class, one of the ways that we establish ijazas and chains of transmission is by knowing the handwriting of the scholar. So if you knew Imam al-Tirmidhi's handwriting or Bukhari's handwriting or Dhahabi's handwriting and you were looking at a manuscript, be like, well, this is not his handwriting. So is there a scribe that said this is I heard it from him or not? So there is evidence even in our own tradition very, very much about intellectual property. So the examples of the ulama writing their intellectual output is something that is the springboard from which we have the discussion about rights in the modern world and things like that. Oftentimes the ulama in the past, especially people who had a lot of hasad towards ulama, like Shaykh al-Akbar ibn Arabi, or Imam al-Sharani in Egypt, people would mess up their manuscripts. They would add like haram things and deviant sentences and clauses, and that's obviously messing someone's intellectual property. So we have that, and the Sharia acknowledges that, and then that becomes a way that we can then link something that we have from our tradition based on the direct reading of Islamic law into the modern application, which we will talk about inshallah more in the next clip. Okay, let's first talk about authorship, because that's kind of one of the examples I left the last clip with. So when somebody writes something, and as a writer myself, I know this intimately, it takes a lot of effort to put your thoughts together, to make an outline, to find the right structure of the writing, to work out the words and the writing, and to edit and edit and edit and edit, and to look things up and to make sure that it's really how you want it to be. And then at the end of that journey, which oftentimes can take a long time and takes a lot of intellectual effort, you have something that's really unique. It did not exist before. Yes, I quoted from Al-Ghazali and Al-Suyuti and Al-Shafi'i and so on and so forth, radiyallahu anhum ajma'in, but I'm quoting them to support an argument that I'm making. So that is something that is a creative act, intellectually creative act. And if I were to take Imam al-Shafi'i's and just reprint it, or if I found a PDF, a high resolution PDF of one of the early manuscripts of al-Shafi'i's and I just preprint it, I didn't really create anything. I just provided a service. We'll get to sort of the copyright in a second, but that's not what we're talking about. We're talking about, I wrote a book. I want to write a book about modern transactions. I'm going to write a textbook level type of book on modern transactions. So I'm going to take everything that I'm telling you and all of the resources I can find and all the fiqh councils I can find and muftis and fatwas and this and that, and I'm going to read it, digest it, make my outline, and then present in a book form what I think. In that case, I have created something that's new, that didn't exist. So therefore, that has to be in my name. No one has the right to take that and put their name on it, because it's not theirs, it's mine. And therefore, if you were to take that work that I did and you put your name on it, then that's a form of theft. And you have stolen my idea. So the Islamic law sees the intellectual creative output as property. It's a type of property, and therefore that's why we call it intellectual property. And therefore, you have stolen it, and then there's going to be damages involved in that. And this also has evidence from the Salaf. Imam Ahmad ibn Hanbal radiallahu anhu, that he opined that it's not permissible to quote a person's work, scholarly work, without attributing it to it or taking their permission. So that, it's often in the modern world, the way that's manifested is like through a release. Like if I find a beautiful picture of, Petra in Jordan, I was like, oh, it's a beautiful picture. I want to use it in my book. And that picture was taken by, the Jordanian Ministry of Antiquities, or I don't know if they have one, or the Jordanian Tourism Authority, let's say. They own that. So they're copyright. They paid for the cameras. It's their cameras. They paid for the photographer. They went out there to Petra and they took these stunning pictures. They monitored the weather. So this is the best day. We're going to vacate the area from all tourists for an hour, and we're going to have a photo shoot. Okay, so that's effort, and that resulting image is not mine, and therefore I have to attribute it to them, and I have to seek their permission to use it because I'm going to be selling books using that image, for example. So Imam Ahmad is saying the same thing. I mean, you can't use it, and therefore, like the Nike swoosh, if I make this thobe and I put the Nike swoosh on it for whatever reason, and I try to sell it, I'm using the power of that logo to make money off of it. So that's not going to be permissible. So haqq ta'lif, the right for authoring something, is something that we acknowledge, the Sharia acknowledges. Now, how about the money that's involved in that? There are two opinions. One very minor opinion that I almost hesitate to even mention to you, and then the majority opinion. The minor opinion is saying you don't have the right to take money off of that if it comes to knowledge creation, because kitman al-ilm, concealing knowledge is a grave sin. And may Allah Ta'ala protect us from ever being amongst that. And then, I think only one of the modern ulama say that. I think it's Sheikh Dr. Ahmed al-Hijji al-Kurdi. The vast majority of the scholars, however, like al-Buti and al-Zarqa, who are they? Sheikh al-Zarqa, Dr. al-Durini, Dr. al-Buti, Dr. al-Zuhaili, etc. There are damages involved in that and money involved in that. You can't just take it. And this is further emphasized by these modern legal agreements. I mean, in no jurisdiction that I know of can you just take someone else's intellectual work as your own. So if I write a book, I have the right to put my name on it, the copyright on it, and to say huquq mahfuda, that the rights are limited and they belong to me. You can't print it or reprint it without my permission. You can't copy it. You can't upload it, things like that, without my permission. So the majority of the modern jurists and the modern fiqh associations and establishments and councils confirm that. So therefore, in the modern understanding, the modern fiqh position is that we affirm the right of authorship, and we affirm the copyright of the author, and we affirm that there is a money implications in the act of the intellectual created work. Money that you're going to use. Well, first of all, you can't just put something out there for free. It costs money to print. It costs money to publish. It costs money to edit and all that kind of stuff. So you've invested money, just like the example I use for this remote control, then the R&D, that's an intellectual R&D, and therefore you have the right to sell it and to make money from it, and that's something that's established, and therefore if that is violated, then the Sharia acknowledges that we have to deal with it the way you deal with things that are stolen. And then in general, so that's sort of I lost my page. That's the authorship, the rights of authorship. In general, then therefore, we have acknowledge the right of inventions. So anything that is invented, like the authorship is something close to us because we're a tradition of scholarship, and we have hundreds of thousands of books and manuscripts and all that. So we know how to deal with that, and the ulama have dealt with that. Related to that in the modern world is to invent something, whether you invent a procedure, whether you invent a product, whether you invent a term or a concept, a way of doing something, a method. All of these things are things that are protected rights, and you have the right as the creator of that to protect that. Sometimes they're called trademark, sometimes they're called copyright, sometimes they're called patents. It depends on what it is, but from our point of view, if you just take a few steps back, they're all the same thing. You're protecting the creative, the result of the creative act. Of course, they are not the same thing. You don't patent a book of poetry that you wrote. I understand, but I'm just saying the concept, the philosophy behind the law is that they're all going to protect that which was created. So the important thing for us in this little lecture that we're doing right now, the second lecture now, in this whole class today, is to say that Islamic law acknowledges the creative process, acknowledges the result of the created process, acknowledges that those are rights that are implied to you if you create something, design something, develop something, medicine, whatever the case may be. You have the right to that, and therefore no one can take that from you without the rights, without permission. Now, some people are generous and they write something and it's for everybody or something like that. But in general, the default implied right, Islamic law acknowledges that. Now, of course, before we end here, just to say, of course, in reality, what ends up happening is that sometimes if you just write your name on something and it's published, even if it's online and you're the first to publish it, naturally by default you own the rights. You don't have to go to register it. But if it's a product or a business or a trademark, you have to go through the mechanism of registering it with some kind of authority. And if it's registered in your local authority, usually my experience is usually the international authorities acknowledge, well, you have the first use of it, so you are the owner of that mark, and therefore theft would be prosecuted. Sometimes you send like a cease and desist letter, so on and so forth. But you have to, with non-intellectual stuff, you kind of have to go through the mechanism of registering it, especially if you're like a scientist and you develop like a formula, equation, or it's something that's almost like a physical thing. You're going to have to register a patent to protect it. Okay, we'll pick up the discussion in the next and last clip, inshallah. All right. Now let's talk about trademarks. So the trademark is that you open up a business. Let's say you open up a clothing business and you come up with a name, Tariq Clothing, and when you open up a business, there are certain basic things that you have to do, whether it's in the pre-modern time or in the modern time, which is you have to advertise, you have to put a sign up so people know where it is, and you're going to have assets that belong to that business. So like cards, bags, packaging, maybe transportation vehicles, and therefore if it's called Tariq Clothing, silly example, I'm going to write Tariq's Clothing in a certain way and with a certain font. And for the sake of consistency and recognition, that name or that font will be on all of my assets, all of the bags, all of the receipts, digital receipts. If there's like a truck or a van that delivers that I own, I'll have the same thing. So that Tariq's Clothing and the way it's spelled, the colors that are used, the fonts that are used become the mark of that business. Not every business's mark is like the Nike swoosh or Coca-Cola the way it's written, or Ford, motor cars. Those are, companies that are pushing past 100 years old and therefore have the longevity of being able to do that. Well, not Nike in that case, but just can be, a symbol can be recognized. But usually, as a bare minimum, it's a name that's written in a certain style and color and format, And for any business to be successful, or even our university, if you look at our the Wise University, you're going to find the name Wise spelled the same way with the same symbol on all, even like when you get emails or like when you go to the website, or if you have a document from the university or certificate, it's going to be the same. It has to be consistent, so you know that it's the same. You can't have every document has the name spelled differently using different color schemes. So that becomes therefore the trademark of that business. And then therefore, that is protected, the rights of the ownership of that are protected by me. In the example that we're using, Tariq's clothing, you can't go take that for yourself and call it Tariq's clothing, because that'd be a way of theft. And if you did that, then I'm going to claim damages, because then you're taking away from my potential revenue. So the Sharia acknowledges all of that. As we've just said, like with the writing and intellectual output, well, I put money into that. And I came up with this idea. It's mine, it's new. It wasn't before, and now it is. And this is the way that I'm selling things, and the type of clothes that I'm selling, or the type of merchandise that I'm selling. For therefore, if you take my name and my mark and use it, there are going to be damages. Now, this happens, believe it or not, in international trade and commerce. These type of disputes happen all the time. There are many, many copycats. Whether they be copycats of consumer goods, whether they be copycats of like restaurants or cafes or individual products. And it's a big, big problem for these big companies, because what they do is when they go to court, they claim damages, loss of potential revenue. And that's something that is acknowledged by secular law and also by the Sharia. So the mark itself, whether it be a symbol and or stylized name, font, color scheme, that's protected. The name of the business, if it's different. So the mark, let's say the symbol and the name. The example that I gave you is just they're both united in one thing, but it is also common that there be a name, a symbol, and a name. And those are two separate things that are also protected. And number three, what that mark stands for. So, if in other words, what am I selling? What am I putting out there? The product or the service that I'm putting out there. All that's going to be protected. It's protected in the same way that an author, the authorship of a certain work is protected, an intellectual output, and based on the classical understanding, we quoted Imam Ahmad ibn Hanbal radiallahu anhu earlier about not being able to take something from another alim without attributing it and or acknowledging, attributing it and or taking permission. So therefore, if that's considered a type of theft / ownership / theft, then min bab awla, it makes even more sense that in the modern world, like I'm using this because it's in front of me, the Sony, I can't know if you can see it, but Sony is written on the bottom of this remote control in a certain font. So I could write an article about Sony and use the word Sony all out my article, that's fine, but I can't put together a product and then write Sony the way it's written here and then sell it. That means I have stolen this mark. So those marks are protected in modern law. And then this, by the way, is all international agreements. I don't know the names of the agreements off the hand, but there are these like international treaties, trade treaties and things like that, in which sometimes, because small businesses can't, like I said earlier in the first, they can't afford to register in like 200 countries. I mean, it's just cost prohibitive. You can barely register in one country and maintain it. So sometimes international trade, country A agrees with country B, and everything that's registered in country A would be registered in country B and vice versa. So those type of agreements agree. There are some agencies that you pay a little bit of extra money and they will offer like kind of a maybe like 80% of the world type of registration. I've dealt with some of those things in the past, and therefore that's protected. So وَالْمُسْلِمُونَ عِنْدَ شُرُوطِهِمْ, the Muslims are at their agreement, as the Prophet sallallahu alaihi wasallam taught us. So therefore, when our Muslim majority countries sign these agreements, we are beholden to them. So we can't allow people, Muslims in those Muslim majority countries, to steal the stuff from other people, because that would be considered a theft. Why? Because we acknowledge the right and the ownership of that mark because we acknowledge the implied mark of ownership of the intellectual output. That's kind of the summary of what we're trying to say in today's class. Let me just pop in here really quickly to make sure there's nothing else I wanted to say. So by point of reference, the Majma' al-Fiqh al-Islami in its fifth gathering that took place in Kuwait acknowledged the right of authorship, the right of creativity, marks, trademarks that is, the names of trade names, that they are all considered personal rights, حقوق خاصة لأصحابها. So the people that put them together, or peoples if it's a company, they have an implied right to ownership to that. Saying that there's an implied right equally at the same time means that there's an implied value to that. So if I write a book, if I write a diwan of poetry, and I'm a poet, then there's automatically, it's mine, you can't take it without my permission, attribution, etc. And sometimes you can attribute only a certain, you can't take the whole thing and then say, oh, Tariq wrote that, because that's also theft by just another means. Sometimes you can quote it, but only a portion of it. And therefore, implied in that is a value. That's the key, is that there's a qima, there's a value to that. Just like there's a value to land, just like there's a value to livestock, just like there's a value to money, like there's a value to clothes, there's a value to a home, to assets, there's a value to that right. And therefore, that's why we're talking about it, because you would be very, very surprised to see how prevalent these type of disputes, as I mentioned, are. So therefore, there's an intrinsic value, sorry, I lost the word there. There's an intrinsic value to that right. And therefore, the Sharia acknowledges that no one has the right to violate that right. And if they did, God forbid, it would be considered a type of theft. When I was in Egypt's Dar al-Ifta working, we had a couple of interesting cases where very big brands in the Middle East came to Egypt's Dar al-Ifta claiming that, I don't want to name the brand, but Egyptian people stole the name and tried to operate. I remember seeing the fatwa saying that this is haram and kind of going through that. So this stuff happens. And therefore, you could take that fatwa and then you could go to the authorities as a support document saying, look, we have a religious edict or religious fatwa, Islamic fatwa saying that this is a form of theft, and then that would carry weight kind of in the arbitration and the disputes in establishing the damages. Okay, I hope that all of that makes sense. The reason we're talking about this is because it's a type of transaction, of course, and of course ownership and money go hand to hand, and that's sort of the whole reason to the kind of the mental thinking is we want to establish that the Sharia acknowledges rights. Embedded in those rights is value, and therefore if the rights are breached, the value is breached, and therefore there can be recompense. Wallahu ta'ala a'la wa a'lam wa sallallahu ala sayyidina wa mawlana Muhammad wa ala alihi wa sahbihi wa sallam. Okay, alhamdulillah, in today's class we talked about rights. We began by reminding ourselves that the Sharia acknowledges explicit and implicit rights. Explicit rights are the rights that come from the text of the Quran, the text of the Hadith of the Prophet sallallahu alaihi wasallam, and confirmed by the consensus of the people, the generations before us. But there are also many rights that are implied, and I use the example of the man having the implicit right to make a divorce pronouncement to his wife. It's not like something that you're walking around in the marriage like holding it in your hand, but it's implied that if you're a husband and you're married and you have a wife, then implied in the relationship you have the right to issue a divorce pronouncement, just like she has the right to seek recourses for any type of darar or damages. It goes both ways, by the way, lest anyone think that this is one-sided. And those are implied rights. So first we abstract from those specific examples and say, okay, Islamic law acknowledges rights, explicit and implicit. Second point, does Islam acknowledge intellectual rights? Are there intellectual rights? And we look at the example of authorship and the creative act of writing and scholarship, because we are an ummah, mashallah, of tremendous scholarship, and be like, yes, this is something that the ulama were obsessed with. And we quoted Imam Ahmad ibn Hanbal radiallahu anhu that you can't take anybody's writing without either attributing it or seeking their permission. So therefore, Islam says, yeah, we say yes, Islam acknowledges intellectual rights. So intellectual rights being the creative act, a piece of art, technology, business, trade, formula, equation, process, all of these things can be copyrighted, trademarked, patented. Obviously, those words mean different things for the different types of things, but in general, we can protect them. And the reason we can protect them is that associated with those things, other than the creative act being acknowledged and protected in Islam, associated with that is an intrinsic value. That you're going to take that piece of art, literature, scholarship, process, method, etc., and sell it. And therefore, if somebody were to take that from you, they have been you have the right to pursue damages because they have taken potential revenue loss from you. And this has been confirmed, as we said, by the modern fiqh positions, and we kind of gave some of those examples. I hope that that's clear. Inshallah, I think that's enough by way of review. Wallahu ta'ala a'la wa a'lam. Wa sallallahu ala sayyidina wa maulana Muhammad wa ala alihi wa sahbihi wa sallam tasliman kathira.